In a significant blow to the former presidency, Jacob Zuma has been ordered by the Gauteng High Court in Pretoria to repay a 28.9 million in legal fees previously funded by the state. The judgment, handed down by Judge Anthony Miller, addresses costs incurred during Zuma's private litigation over many years. The court's order also imposes interest and sets strict repercussions if payment is not made within 60 days. The sum owed, are 28,960, 774.34 to the state attorney, is substantial. The judgment holds that interest will accrue on at least a 18.9 million of that amount beginning January 25, 2024 and continuing until full payment is received. The court further specified that should Zuma fail to satisfy the debt within the allotted 2-month period, the state attorney is authorized to have writs of execution issued and assets seized. These could include his movable and immovable property and, subject to further court permission, portions of his presidential pension benefit. The case stems from the state's effort to recoup expenses related to Zuma's decades-long private legal campaign. Over the years he pursued numerous cases, often funded in part by the state, including matters tied to high-profile corruption allegations. A 2024 ruling by the Supreme Court of Appeal had already determined he was not entitled to taxpayer-funded legal support for the bulk of that litigation and paved the way for the current recovery action. From a governance and public policy perspective, the ruling underscores key themes: accountability for public expenditure, the limits of state-supported litigation for high office holders, and the enforcement of fiscal responsibility even against powerful individuals. The court's decision sends a message that taxpayers' money cannot be indefinitely used to fund private legal battles of former presidents without recourse. For Zuma personally, the ruling introduces fresh pressure. In addition to the legal liability, the market of his assets and the enforceability of the judgment create potential financial exposure. The order to file progress reports by the state attorney every 3 months until the debt is settled ensures that the matter remains under court supervision and public visibility. Defense arguments in the case have claimed that Zuma should not be held personally liable for the payments since at the time state support was given, official policy and approvals existed. His legal team argued that he was a beneficiary of decisions made by the executive branch and that recourse against him alone is unfair. Nonetheless, the court found that as the ultimate recipient of the funds, his personal responsibility is enforceable. The timing of the judgment is significant. It coincides with broader public frustration over governance failures, misuse of public funds, and inner circle access to state resources. For the ruling party, and for state institutions managing accountability, the case offers an opportunity to demonstrate that financial obligations are not shielded by political status. For opposition parties and civil society groups, the decision provides tangible evidence of judicial willingness to hold a former head of state to account financially. However, the judgment also raises practical questions. Can the state realistically recover such a large sum from a politically prominent former leader? What assets does Zuma possess that are not encumbered or contestable? How will the enforcement teams proceed with asset tracing, pension attachment, and possible liquidation if he fails to honor the payment schedule? Beyond the immediate ruling, legal observers see this case as a potential precedent. It may influence how state-funded legal representation of senior officials is handled going forward. If former office holders can be made to repay costs, future claims may face greater scrutiny from the outset. This could lead to policy revisions in how the state approves and funds legal representation for senior officials and how recovery is pursued where approvals are later adjudged improper. For the public, the significance lies in restorative justice, not merely in seeing funds returned, but in reinforcing the principle that even former presidents may be obligated to reimburse state-funded legal expenses when they relate predominantly to private or non-official activities. If the money is successfully recovered, it would mark a win for public fund protection. If not, it may raise deeper questions about whether formal judgments against powerful figures are enforceable in practice. In summary, the Gauteng High Court's order for Jacob Zuma to repay nearly R29 million aligns with growing institutional emphasis on accountability, the proper use of public funding, and the enforceability of court-ordered financial liabilities. It presents the state with both an opportunity to recoup taxpayer funds and a logistical challenge in execution. For Zuma, it is a pivotal moment, one where legal liability, financial exposure and public perception converge. Whether this case results in full repayment, partial settlement or prolonged litigation will have implications beyond one individual. It will reflect on South Africa's ability to hold its most powerful figures to account financially.